I mean, they both are so intertwined. How do you separate it all out?
They're not intertwined. All right.
I mean, how do you present? How do you present the case without something about the other one being involved because they're the contractor?
Well, you can talk about them as the contractor. You just can't explain to the jury or elicit testimony that they were damaged in any way because it's been settled.
You're right.
So, in other words, you don't even want no evidence of even them that they're out of business now?
No. The fact that they had a banking relationship with Fifth Third, any of that none of that's relevant to this case. This case, Your Honor, is about whether or not Fifth Third breached a contract with City Center. There is no claim left whether or not there's been a breach by Fifth Third of any loan documents with Hawk. That's been settled. There's a release, and there's a dismissal. If they want to say Hawk was the general contractor in the project, they can testify to that. And what their role was in the project, that they can't get into any evidence regarding whether or not Hawk was damaged by City Center and what those damages are.
Okay. Beef?
I certainly would like to keep that out. Hawk was the general contractor, and by killing the general contractor, they killed the project. It was an intentional focus on killing both. When stopping the funding of City Center didn't work, then they went after Hawk. And you'll hear testimony, Your Honor, that Hawk was continuing to function through August. The bank went in and swept all the money out of Hawk's accounts so it couldn't make payroll for the people who were working on the City Center project.
All right. What I will do is I'll reserve this for trial and see where it goes. Okay. So now we're at 2.
And Your Honor, I don't have any objection to the deep pockets argument.
Right.
So I guess if that's all it's going to is that they have deep pockets and ability to pay, I don't object to that portion of it.
All right. Any testimony or argument of unequal bargaining power, there's no claim of unconstitutionality granted. Okay.
Your Honor, we have made a claim for the bank's exercise of undue control over the project and involvement. The bank told City Center what to do, and City Center did it. That was the way the relationship worked.
Is that bargaining power?
That's a different issue. That's a different issue. I'm talking about
and saying that
number 3 relates to going into the agreement.
Right, and saying that they were forced into it by some way because they...
Right, or that due to some duress or something of that nature, they were forced to take this agreement. That's what that goes to.
Right.
That type of argument.
So this is all pre-August of 2005 is what you're going to do?
Whatever the promissory security agreement.
The loan agreement was October 21st.
Then it would be anything prior to that date, any argument prior to that date that duress or something made the contract unconscionable.
Yeah, I think, and if that's what we're saying, I'm okay with that. I think the duress and unequal bargaining power comes in after the signing of the agreement.
All right. Any mention that City Center was Any mention City Center was forced into bankruptcy by the creditors, having no bearing on liability of bank damages are sustained by City Center.
I'll take this one.
Go ahead.
No, you have an objection to that?
Well, I do think that this was part of the killing of the project. The bank was involved in this as well. Right in the midst of our depositions, we were forced into bankruptcy, and the case killed, and the bank bought off one of the claims for $30,000. They were both the creditor and the settler. Essentially, they paid themselves to make it go away.
I'm not sure what Mr. Beach is talking about. Here's what I know what's true here is that there were 3 or 4 subcontractors that filed an involuntary bankruptcy against City Center. That bankruptcy was filed, I believe, in Lake County, Indiana. It ended up being transferred to Judge Dees in South Bend. There was a lengthy trial on whether or not that was a proper filing by those subcontractors of that involuntary bankruptcy. At no time in any of those bankruptcy proceedings was there any evidence that Fifth Third was one of the participating creditors that petitioned for the involuntary bankruptcy. The fact that there was involuntary bankruptcy filed by 4 subcontractors and not Fifth Third has no relevance to this case, and it should be excluded.
Your Honor, maybe a little more background would be useful. The bank had a first position for about $4 million, $4 million plus. This court took City Center into receivership and sold it for $2 million and something. So there was $2 million some dollars to go around. All of the subs were in a secondary position. They wouldn't get anything unless more than $4 million was collected. The only asset that City Center and Hawk had remaining was this claim. And when we went to bankruptcy court, what ended up happening, this claim, which was the only avenue for the subs to get paid, was bought by the bank, they claimed against Hawk, for $30,000. So the subs got nothing. As the first creditor, the bank approved it, not because we think they thought $30,000 was a fair value as a creditor. They approved the $30,000 because they were a defendant and they didn't have to show up in court. And the reason that the bank approved that payoff as a creditor, I think, is very relevant. That's all part and parcel of what has been done to kill this project.
I have no idea. I was the attorney who represented Fifth Third Bank in both. There's 2 separate bankruptcies: a City Center bankruptcy and a Hawk bankruptcy. All right. I'm unaware, and I was involved in both cases. I entered my appearance. We purchased nothing from any creditor in any of those bankruptcies. I have no idea what Mr. Beach is talking about.
Fifth Third was the primary proponent of the settlement. They said this claim, as a creditor, they wanted to get back their $4 million. And the only place that could come from was the claim of City Center and the claim of Hawk. There's $2 million in this account. The other $2 million could only come from these claims. And one of them was settled for $30,000. And the reason the trustee settled it is because the first creditor, Fifth Third, who was the only one who was going to get the money, said, we're in favor of it. So as the first creditor, Fifth Third had the ear of the trustee to say, we want the settlement to go through, which just happened to benefit Fifth Third as the debtor. It got him off any risk of liability to Hawk. So that dual relationship, again, goes to the whole course of conduct of the bank to kill this project, and now the cases that were associated.
I appreciate Mr. Beach's creativity here, but it's very simple. We're asking that any evidence or argument that City Center was involuntarily placed into bankruptcy has no bearing in this case. There's 2 bankruptcies. The first bankruptcy, City Center, 4 subcontractors filed an involuntary bankruptcy. We had nothing to do with that. The second bankruptcy, Hawk, 4 subcontractors filed an involuntary bankruptcy against Hawk. What Mr. Beach is doing, he's trying to say because we settled our claim with the Hawk trustee, somehow the evidence of the City Center bankruptcy should get in. We had nothing to do with the City Center bankruptcy. We were not a petitioning creditor. There was a lengthy hearing, a court opinion by Judge Dees indicating that it was those 4 creditors that filed the bankruptcy. There's nothing in that opinion that Fifth Third had anything to do with that bankruptcy.
I mean, are we trying to keep out that these companies are now have been bankrupt completely? Is that what you want to keep out? They're bankrupt?
City centers, not.
The city
City
center bankrupt?
Center's not bankrupt.
The court found that both of the companies, Hawk and City Center, were put into involuntary bankruptcy. The court found that the involuntary bankruptcy as the City Center was improper.
Okay, what is the status of these companies right now?
Hawk has been dissolved, it's been liquidated. City Center it still exists as an entity, but its business has been killed. The only thing that remains of City Center is this claim.
It has no assets?
No assets, no business ongoing at all.
And that goes to either, that goes to our motion limiting is the wealth or whether the poorness of the parties is irrelevant to this case. It's whether or not there's been a breach of a contract.
Well, the issue, so we're saying that through the issue of whether or not they're in business now or doing any business will not come out or should not come out.
Well,
That's our position, Your Honor.
obviously, that's part of our damages. This was a viable company that's been killed by the way the bank handled this loan. They had this business as well as other business opportunities that have been killed. It can't get credit. It can't do business anymore. That's all part of the consequential damages flowing from the bank's course of conduct here.
I think we should reserve this for trial and see just in what context it comes out, how prejudicial and make some rulings at that time. All right, the next one. Any testimony or arguments that the parties' actions amended or modified the loan agreement as against parole evidence rule?
You want me to go first? Your Honor, this gets to the nub of the case. What we think the testimony will show, Fifth Third had an existing banking relationship with Hawk. Fifth Third heavily prospected City Center through Hawk and ultimately were successful in refinancing all of City Center's loan with Fifth Third. Fifth Third prepared a terms sheet that was included with one of the loan documents that couldn't possibly have been met. From the day that we signed that agreement, if that was an intention, we were in breach. Fifth Third administered this loan and funded it for a period of October through July and told City Center what to do and how to do it. City Center did everything it was told to do. And now the bank is coming back and saying, well, you shouldn't have done what we told you to do. There's this other term in the document. And I can give the court an example. The loan document says you may not do business with a related business entity. Meaning City Center and Hawk could not do business together. The only reason the bank even had this business is because of the relationship between City Center and Hawk. So there was a course of dealing where the bank accepted Hawk as the general contractor, dealt with Hawk on a monthly basis, reviewed its work, approved its work, and funded its work to the tune of $4 million, and then said, you know what, they're going to come in here and tell you, the loan document speaks for itself, none of that matters. Never should have happened. The bank has a term in there that says for each building you have to put $210,000 in a Fifth Third account. When Hawk submitted its monthly statement, the bank deducted that $210,000. And now the bank says, well, the loan document says you have to have it in an account. You didn't put it in an account. The fact that we deducted the $210,000 doesn't matter.
Isn't this what I ruled on in summary judgment?
Yes.
Summary judgment.
This is all goes to the course of dealing that was implemented by the bank.
Here it is. That was part of what you ruled on. What counsel said is a clear misstatement as to some of the loan conditions. There's nothing in there saying you can't deal with a related entity. That's simply not true. Now, as it related to Hawk, there were certain loan parameters for their accounts receivable financing. That is, you couldn't have accounts receivable to a related entity to get funding based on that, because what it does is it creates false equity in the other entity. So, and the bankers explained that in deposition. The loan agreement that Your Honor's seen, the note, the loan agreement, the mortgage, they have very explicit terms. And I'll give you another example. It says it will be used for office and retail space. Without the bank knowing, Richard Plank went in and put apartments above the first building. He moved in, his buddy moved in, his daughter moved in. They started using the place for residential living quarters, clearly prohibited by the loan agreements, clearly prohibited by the bank, never approved by the bank. The list goes on and on and on. He changed the zoning. He didn't have required leases. He falsified leases and engaged in fraud, trying to say the leases existed when they didn't, and so forth and so on. So finally, at some point, the bank said, look, you haven't satisfied any of these requirements, and they gave him months to try to come clean, to fix it. They gave him the opportunity. He didn't do it. They've never waived any loan requirements. There's nothing in writing saying we waive any loan requirements. It's just never happened. So he wants to get in all this parole evidence that, you know, this was said and this was said and I was told this, and there's just no evidence of it. We have a statute that's directly on point. It says unless it's in writing, it doesn't come in, it's not admissible, it's not competent evidence, and the court or the jury, whoever is going to hear the case, shouldn't consider it. Now, whether there's an issue of fact for summary judgment purposes is one thing, but to go contrary to a statute that says this evidence is not admissible, that's an entirely other issue, Your Honor.
Your Honor, the court is absolutely correct. This is what we discussed at length in summary judgment. The statute does require a written loan document, but it allows claims both in equity and in law based upon that. We've cited the court before to the Seas versus Bank 1 case. That's the Indiana Supreme Court, 839 Northeast 2nd, 154. And also the Citizens Financial Services versus Innsbruck case, 833 Northeast 2nd, 1045. Both of those cases talk about the course of dealing where you have substantial reliance on a course of conduct that's engaged in here that is allowable as a claim. It is a viable claim. It prohibits conduct just as what's happened here. And we have written documentation from the bank in the form of emails telling City Center, do this. And we did it. That was the only way they would fund the loan for a period of months. And now they want to come back and say, ignore all that, have the court tell the jury to ignore all of that. It doesn't matter. And the cases I've cited, the court will not allow the bank a get out of jail free card for that conduct.
Cease was overruled by statutory modification. Everyone knows that. Cease is no longer good law. You can't rely on that. The statute was modified. Unless it's in writing, either for a claim or a defense, it's not admissible.
All right, well, we'll just hold that over to trial and see how this tries to get in. We'll rule it appropriately then. Testimony or argument about the administration of any loans other than this one.
That goes again, Your Honor, to what was done to Hawk to help kill the City Center project. Hawk is the general contractor that is work from City Center is getting paid by City Center. Bank says we won't let you pay Hawk anymore. Hawk has its notes with the bank. Bank says we're going to sweep the money out of your account. So now you've got a general contractor. It can't get funding from its client, and it can't even make its payroll. That is what put the final nail in the coffin of this project.
Your Honor, I think it's simple. What I would request the court is to supplement our motion in limine and provide the court with a copy of the general release signed by Hawk and the stipulation of dismissal with prejudice of all their claims, because I believe if the court reads those documents, it's clear that whether or not there was a breach of any agreement between Fifth Third and Hawk, those claims have now gone away. They're clearly prejudicial for the jury to hear a settled claim that they've been damaged in front of a jury. That's just not proper, Your Honor.
None of my comments to the court are to suggest that we're asking for damages for Hawk. We're not talking about the claim. The injury inflicted upon Hawk was part and parcel of the attempt to kill the project of City Center. That is all. What was done to Hawk is all evidence of the claim of City Center.
Your client?
What's that?
Well, how it impact?
Yes. Yes.
Your Honor, if this is a car accident and the passenger settles, if the car gets rear-ended and the passenger settles, you cannot bring into evidence that that passenger was injured and that passenger sustained damages to prove up the driver's case. That's what they're trying to do in this case. The general release disposes of all the claims of Hawk. They want to now tell the jury that Hawk was damaged, and they were damaged, and they settled with Fifth Third, and so we should get damages too, Your Honor. That's totally improper.
We're not mentioning settlement. And if you want to use the car accident analogy, this is a three-car accident. The bank rear-ended Hawk, which rear-ended City Center. They settled with Hawk, and they want to pretend like that car doesn't exist. It's all part and parcel of the chain of events that led to the injury of City Center.
Well, it's not a car accident case, Your Honor. It's a contract with Hawk and a contract with City Center. They're two separate agreements.
All right, let's withhold this one until trial.
Your Honor, if I could supplement and send to the court the stipulation dismissal and the settlement agreement.
Okay.
Thank you.
You know, we're not disputing that the claim of Hawk was settled. We're not going to mention the claim. We're not going to ask for damages. They're simply an actor that led to the damages to City Center. Number 7, Your Honor, we haven't even taken the 30B6 deposition yet. I'm not sure what testimony they're referring to there. Obviously, there's different witnesses with different accounts. They can impeach one with the other. Certainly, if the 30B6 witness says one thing and somebody else says something else, that's certainly fodder for cross-examination. We have that same thing with the bank's witnesses. Their 30B6 witness said one thing, some of their employees said the other. That's why we have trials and cross-examination. It's not something that gets excluded.
I have no issue if number 7 is made mutual. We can make it mutual as far as that's concerned. All I'm trying to prohibit is if one person testifies on a 30B6 deposition, gives testimony binding the company, I want to prohibit them from another witness getting on the stand and testifying contrary to that, because the 30B6 deposition binds the company, and another witness can't get up and then test differently at trial. That's what the rule is for.
And I think there's avenues for a party to use. Certainly we will intend to do that too. We ask the court to instruct the jury on the significance of a 30B6 witness and what that testimony means. Each witness still gives their own account of what they recall. And there's going to be different recounts, and the court can instruct the jury on how to use a 30B6 witness.
Counsel misses the point entirely. You designate a 30B6 representative for the company. That representative testifies on behalf of the company what the company knows, not as to their own recollection or what they personally experienced. They testify as the company. If a different representative then takes the stand to testify as to those same matters, they're not testifying from their own recollection or experiences. They're again testifying as the company. They cannot then testify differently than the corporate representative at deposition and say, well, that wasn't me. That defeats the whole purpose of a 30B6 deposition.
So in other words, you say you might have one person deposed and another person testifying?
I think I've heard that already. That may be
Who's the
the
company representative that's going to be testifying?
I think we're going to have 2 or 3, Your Honor. Part of one of the issues, my principal, Richard Plank, when after the bankruptcy was filed, had a stroke. He's in a wheelchair now and is significantly incapacitated. He has his cognitive abilities, but he can't sit for 8 hours at a time. So we're trying to put together others that can come and testify, and we're trying to figure out how best to do that. Obviously, the company is no longer operational, so there are no other employees. And again, we're not suggesting that we're going to undo our 30B6 testimony. That stands. But we still have witnesses that come in as individuals and offer their own testimony and perspectives. And if it's inconsistent, then they can use the 30B6 to cross-examine.
Right. If they have 3 different individuals testify as 30B6 representatives, they can certainly do that because they may have particular knowledge as to a certain area. But once they give a deposition, let's say individual 1 testifies as to the specifics set forth in A, number 2 in B, number 3 in C. I don't want number 3 coming here to trial testifying to items A that number 1 testified to in deposition and saying, no, now we change our mind as a company. Once that deposition testimony is set, and this applies to both sides, it's equally compelling for both sides. That is, Fifth Third couldn't now bring someone other than their 30B6 deposition representative, have someone else from the bank testify at trial, inconsistent with what that person testified to.
At this point, do we know what anybody's going to...
No, we already had the tested.
Why don't we reserve this also until trial and know what they're testified to and see if there are any objections at that time? Or after the depositions. You're planning on deposing these people?
Yes.
Yes.
Okay. Next one is testimony or argument of any damages or other compensatory damages consequently related to breach of contract.
In general, Your Honor, I don't have an objection to that. We obviously have a claim of equity, we have an undue control claim too. It's not just a breach of contract case, but the damage is flowing as an element of each of those claims we're fine with.
Okay, so we're okay with that one. Any testimony regarding community involvement, charitable acts, or contributions of City Center?
I'm fine with that one as long as it goes both ways.
Hey, is that all right, Mr. Woodward?
That could be mutual.
Any mention of this motion eliminating or any suggestion that the bank sought to exclude certain evidence? I'll grant that. Testimony from lay witnesses on subjects that require knowledge of experts. Is there any problem with that one?
Your Honor, I guess the devil's in the details. I don't know what that's going toward. I have a contractor and a superintendent who worked in this project. They're going to give construction information and testimony. I'm not sure what that's going toward.
I'm going to say if you lay the proper foundation, I guess.
Right.
Some experts.
Right.
Yeah. It's a foundational issue, I think.
Yeah. And just, okay.
Okay. Any testimony or argument or suggestion regarding economic hardship, a judgment against City Center would cause, or that a judgment would give prices increases City Center is a small company that cannot sustain a loss.
Your Honor, we don't intend to talk about what would a judgment against City Center. That's not. Obviously, there will be a lot of testimony about the economic hardship to City Center, but not as a result of a judgment.
Okay. Is that all of them?
It is.
I believe. Anything else, gentlemen? Anything else we need to address this morning, other than...
Well, we are finishing up some discovery that we weren't able to complete for various reasons on both of our parts, but we'll continue to get that done before trial. We're still looking at mediation as a possibility.
Are you? Nice.
It's going to be difficult to get it in, but we're trying to.
So when are we set? We're set for
March 11, Your Honor.
March 11. Okay. We're set for 10 days? Is that what we're set for?
Your Honor, I think we can finish it in 5, perhaps 6. And what has happened, you'll see both parties have a list of about 20 bank employees. We've found that there's about 3 or 4 that were the actual actors. And all of the others, it's been represented to me, their knowledge is based upon those 3 or 4 actors. We've agreed to, and those were all depositions that were going to be taken, we've agreed to forego those depositions with the understanding that none of those witnesses will be called.
Right.
So we're really looking at, I think, 4 bank employees, and I've got 2 or 3 fact witnesses on my side. So it's going to be a lot more streamlined than it might have been.
Well, if we can get it done in 5 days, then...
Well, we've talked about 5 days, Your Honor, but...
well, I've got 2 weeks there.
yeah,
I've got 10 set aside.
we're thinking, in worst-case scenario, 7 days.
In the very worst, yeah, I could see it going Monday. I don't see Tuesday, but certainly I can't imagine any scenario that would go over 7 days. That would be a full day of testimony from each witness.
Okay, have there been any settlement negotiations?
We did, a long time ago, Your Honor, have a settlement, actually I think 2 settlement discussions. And that was actually before the receiver had sold City Center. There have not been any, what I would call productive discussions since then.
Your Honor, all the settlement discussions were at least 2 years ago. Because of some of the rulings that occurred over the last year, Fifth Third is willing to go to mediation. The problem was, and Mr. Beach and I worked about 45 days ago on a date with Van Winkle out of John Van Winkle out of Indianapolis, and unfortunately I had a family vacation when I scheduled that with David, and I apologized to him already. I'm going to be out that day. We're trying to get back in with Mr. Van Winkle prior to the trial, but the difficulty is with getting some of the last-second discovery done, and then Mr. Van Winkle's schedule. The dates we're looking at are like the Tuesday or Thursday before trial, which I don't think either one of us are real excited about mediating that close to trial. So we're kind of in a little bit of a predicament with respect to mediation. As you know, the court knows here, is this case was initially scheduled as a primary this summer. I was hoping that if we did not have, if we were not going next month, that I was going to talk to Mr. Beach today about being able to schedule a mediation in lieu of the trial setting, but that didn't occur.
How do you feel about that, Mr. Beach? How do you feel about it?
Well, my client is willing to participate in mediation, but we do want to get this case tried. And, if it was something where we could push it back a week or 2, that would be fine, but to, push it back to August is a long time. And
Okay.
I don't know what the court's calendar, if we could...
Even April, we would be, April trial date would give us, in lieu of that 2 weeks we had marked off in March, we could surely mediate it then, if we had an April date.
I don't think I do, but we can check.
The other thing, we had talked about it in January, but we haven't discussed it since then. I'm just thinking to save time, The city center nominated an expert, and I don't know what his opinions are, the basis of those opinions, or his qualifications. I'm thinking it could result in significant delay to voir dire that individual if we don't know those things ahead of time. Could he be made available to give his opinions?
I'll produce him for deposition.
Okay, all right. That'll speed things up also.
And I had all these Weinberger trials that kept falling off. That's why yours got bumped up to March. And I think they're all going to fall off, but I only know the first 3 this year that have fallen off so far. They're working on some kind of universal settlement, I know.
Hey, Judge, you got a 2-week trial starting April 8th with that Vitros.
Oh, that's right.
So,
How about the first week of May?
You said April 8th?
8th is out.
first week of May.
Is that trial you think going to go in April?
Oh, yeah.
It is?
What trial is
I'm
that?
pretty sure that's the former mayor,
Yeah.
Mitros, whose son died as some kind of overdose pharmacy.
Right.
I know they settled out with some of the defendants, but they haven't settled with the doctor, who's pro se.
He's pro se?
Oh,
It's going to be 2
oh
weeks.
my. That's something.
Well, I don't think it's going to be 2 weeks now because the pharmacy's settled out.
What if we could have that second week?
Starting that Weinberg case, Judge, we don't know which way that's going.
I'll tell you what, why don't you gentlemen see what you can get accomplished between now and then let's maybe by then something will fall off here. That Mitros case isn't going to go 2 weeks, is it? No. Yeah.
Who's plaintiff's counsel in that case, Your Honor?
Canal. I think it's only going to go 1 week, if that. We'll call him.
Would the court entertain maybe a conference call or a quick status call the week, or maybe before our trial, to kind of, so we can bring up the
I mean,
date?
see where you get, and then if something falls off, I'll try to accommodate you and get something.
Okay. You want to do it for, I'm sorry.
We'll see what that happens to that Mitros case. I mean, you might,
April 22 and 29 doesn't work for somebody?
April 22,
That works for me.
that's open?
We can.
We can do that.
Yeah.
That
That way we can mediate it during March, for sure.
would be fine, Your Honor.
Okay.
What's the date?
And the
April
29th,
27th.
you can say 2 weeks.
They think like 7 days.
At the most.
At the most.
And we,
So then the April 29th week is okay with you also?
yes.
Yes.
Good, that we'll be able, we'll get our discovery done and have time to mediate it.
You want to just, as a matter of formality, I don't think there's any objections to this, but the court has in front of it the pretrial order that has all of the witnesses, all of the contentions, and all of the exhibits that have been submitted by every party. The court will note that nothing was submitted by IB&B, Lazaro, Hawk Enterprises, Curly Masonry, Electrical Construction and Design, Young Plumbing, C&B Steel, Bloomfield Mechanical, Huminger Landscaping, Falk Design, and Coex Inc. Given that there's been no witnesses, no exhibits, and no contentions, we would move for judgment on the evidence as to those parties who have not submitted anything and have failed to put forth anything by which they could make a prima facie case.
Objection?
Nope.
Okay, granted.
McDaniel Fire Systems,
Right, yes.
there may be others that haven't been
Yeah.
combined there.
So we're definitely vacating the March?
We're vacating the March, yes.
You want me-
That's March 11th and 13th now.
Does the court want me to prepare a formal motion and proposed order for that motion for judgment?
Yes.
Okay, I'll do that and submit it.
Anything else?
No, Your Honor. That's it, Your Honor. Thank you.
All right, gentlemen. Thank you.
Thank you.
All rise. The 11th and 13th for those steps, and you don't have to worry about it.
You